Thank you, Mr. Chairman, and thank you, Madam Speaker. I rise to speak enthusiastically in support of my bill, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. 5 years ago, the Washington Post published a story that shocked me to my core. 69,000 women were suing Sterling Incorporated for sexual harassment, sexual assault, and sexual discrimination. Sterling is the parent company of Kay and Jared Jewelers. And yes, I did say 69,000. I had to double-check that over and over. Not 69, not 6,900, 69,000 women. If you didn't do what he wanted with him, you wouldn't get your preferred store or raise. That's what Sonia Douglas, a former employee, testified. A boozy, no spouses allowed sex fest where attendance was mandatory and women were aggressively pursued, groped, and harassed. That's how meetings at the company were described. You were meat being shopped. That's how a former employee described her workplace. Each story was more disturbing than the story before it. Managers demanding sexual acts in exchange for employee benefits. Company events where women were expected to undress publicly. In one story, a former employee attended an overnight meeting where she woke up with her underwear pushed down to her ankles, a manager raping her. This type of sexual perverseness in the workplace went on for years, and it all stayed secret. And the reason for that secrecy? Because of one single legal clause hidden deep down in these women's employment paperwork. A clause that says, if a claim arises between an employer and an employee, it must go to arbitration. And taking a case like this to court is prohibited. My bill would make it illegal to enforce agreements that mandate third-party arbitration, which is a type of legal dispute resolution that is conducted behind closed doors and often favors the employer. Seems simple, right? Well, that one tiny clause protected a company of abusers and silenced those 69,000 women just at Sterling Incorporated. That's just one single company we're talking about, but the stories go on, and the bad actors aren't just at workplaces. While 60 million, that's 60 million Americans are working under these forced arbitration clauses through their employers, the real number of people impacted by this incredibly common pitfall is huge. Many more millions of Americans have signed away their rights through property leases, rideshare applications, moving companies, nursing homes, grocery deliveries. That terms and conditions box that we've all simply checked off after downloading an app or hiring a service that might just have an arbitration clause hiding in it, ready to strip away your right to go to court if you have been sexually harassed or sexually assaulted and you choose to go to court. While some companies have already eliminated this abusive practice, thank you to them, it's time to do away with these legal traps for good. The Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act will invalidate any forced arbitration clause in any contract or agreement in the case of sexual assault or harassment. And I'm proud to say that my bill has widespread support among Republicans and Democrats over at the Senate and here in the House. I want to thank those who have helped us get here today. I want to thank Representatives Pramila Jayapal, Morgan Griffith, Ken Buck, David Cicilline, Chairman Nadler, Senators Gillibrand, Lindsey Graham, and Dick Durbin, and our fearless champion on this, Gretchen Carlson. I urge my colleagues to support this, and I look forward to the day when our sexual assault survivors can have their day in court. With that, I yield back.
Gentlelady from Minnesota.
Madam Speaker, I yield 2 minutes to the gentleman from Virginia.
Gentleman's recognized for 2 minutes.
Thank you. I appreciate that, Madam Speaker. I rise in support of H.R. 4445, the ending